The Delhi High Court on Monday held that the police or any other agency cannot use media to influence public opinion to accept that the accused is guilty of an alleged offence while the matter is still being investigated.
Justice Vibhu Bakhru observed that the same is not only likely to subvert the fairness of the investigation, but would also have the propensity to destroy or weaken the presumption of innocence, which must be maintained in favor of the accused till he or she is found guilty after a full trial.
It is also well settled that the right to receive information is one of the essential facets of Article 19(1)(a) of the Constitution of India. The right to freedom of speech and expression also encompasses the right to information. However, this right is not absolute and may be curtailed if it interferes with the administration of justice and the right of an accused to a fair trial.
The question whether media reporting or disclosing of information by the investigation agency has the propensity to prejudicially affect fair trial would depend on the facts of each case.
Concededly, there cannot be any blanket order prescribing the Delhi police from disclosing any information regarding pending cases. The question whether reporting or publication of any information relating to a case pending consideration in a court has the propensity to subvert fair trial or to interfere in the administration of justice must be examined in the context of the facts of each case.
The relevant factors to be considered would include the nature of offence for which the accused is being tried, the stage of investigation of trial, the nature of information, the vulnerability of the persons involved, accused, witness, victim, or in some cases even the investigators, and the intention and purpose of circulating information.
Selective disclosure of information calculated to sway the public opinion to believe that an accused is guilty of the alleged offence, to use electronic or other media to run a campaign to besmirch the reputation or credibility of the person concerned, and to make questionable claims of solving cases and apprehending the guilty while the investigations are at a nascent stage, would clearly be impermissible. This is not only because such actions may prejudicially affect a fair trial but also because it may, in some cases, have the effect of stripping the person involved of his/her dignity or subjecting him or her to avoidable ignominy.
It is trite that the right to live includes the right to live with human dignity. The Supreme Court reiterated that the reputation of a person is his valuable asset, and is a facet of his right under Article 21 of the Constitution. Human dignity is a constitutional value, and any action that unnecessarily denudes a person of his dignity would have a debilitating effect on the rights guaranteed under the Constitution of India.
At this stage, it would also be relevant to refer to the office memorandum issued by the Ministry of Home Affairs, Government of India. The said office memorandum contains an advisory on media policy of police. It lays down the guidelines that are to be scrupulously adhered to while dealing with the media.
The said guidelines, inter alia, stipulate that only the designated officer should disseminate information to the media on major crimes and law and order incidents, important detections, recoveries and other notable achievements of the police. The police officials should confine their briefings to the essential facts and not rush to the press with half-baked, speculative or unconfirmed information about ongoing investigations. It is also stipulated that the briefing should normally be done only at the following stages of a case: A. Registration, B. Arrest of accused persons, C. Charge sheeting of the case, and D. Final outcome of the case such as conviction, acquittal etc. The due care should be taken to ensure that there is no violation of any legal, privacy and human rights of the accused, victims. And, the police while briefing the media should not make any opinionated or judgmental statements.
The petitioner has filed the present petition, inter alia, praying as under, issue a writ of mandamus directing the respondent Delhi police to not leak any allegations pertaining to the petitioner to the media pending investigation, and thereafter during trial.
Issue a writ of mandamus directing the respondent Delhi police to forthwith withdraw all allegations contained in the brief note, dated 2 June 2020.
The petitioner is an accomplished student and is currently enrolled as a student in MPhil PhD program with the Department of Women's Studies at the Jawaharlal Nehru University. The petitioner claims that she has participated in several peaceful campaigns protests and is actively involved in issues concerning women.
The petitioner claims that she is a critic of the Citizenship Amendment Act, 2019, CAA, and has been questioning the lack of response on the CAA from institutional agencies. The petitioner claims that she believes that the CAA is unconstitutional and has participated in peaceful protests for seeking repeal of the CAA and a stop to the National Register of Citizens (NRC) process.
The petitioner claims that she has all along advocated a peaceful approach to the criticism of the AA. She asserts that she firmly believes in the principles guaranteed by the Constitution of India and has chosen to criticize the CAA believing that the same is unconstitutional.
The petitioner's grievance in the present petition stems from a brief note, dated 2 June 2020, hereafter referred to as the impugned note, circulated by the Delhi police to various media agencies. The impugned note disclosed names of 2 girls including the petitioner and alleged that they belonged to Pinjra Tod group and were actively involved in hatching a conspiracy to cause riots near Jafrabad metro station. The cases concerning communal riots are undoubtedly sensitive cases. This court is also informed that FIRs filed in such cases are not being publicly disclosed. In the circumstances, this court considers it apposite to direct the respondent not to issue any further communication naming any accused or any witness till the charges, if any, are framed and the trial is commenced.